captioning starts working, Garin will jump in, I'm sure, and let us know what to do. So welcome to our rights and recourses for workers during COVID-19 training. We're so happy that you joined us.
And Dora, the closed captioning is now working.
All right, great. Just in time for the accessibility note. So this webinar is being recorded. You're automatically on mute, so please don't unmute yourself. Speakers, feel free to unmute yourself and mute yourself whenever, and just know that if you're shuffling papers, people can hear you. This is being recorded, and we have a closed captioner, so if you go down to the very bottom of your screen, there should be a little box with double C. If you need closed captioning, you can click that on and it will turn on. Because we have closed captioning, we're going to ask our speakers and ourselves to kind of speak clearly and slowly so that the captioner can get as much of what we're saying as possible. If you have questions, feel free to use the Q&A, which is also at the bottom of your screen, to ask any questions, and Garin will make sure that we address your questions. Garin, you want to talk real quick about the evaluation?
Yes. So an evaluation is required for those seeking MCLE credit, but we do encourage feedback from everybody to let us know how this training went, how the slides were, and so that way in the future we can better tailor trainings to how you'd like to see them. When you click exit on the Zoom, when you leave the Zoom after it ends, the browser will open up a tab in the internet that your the internet, like Chrome or Safari or Firefox that you are currently using, and you would select continue in the blue box instead of exiting the tab. That way you can exit, or you can access the survey.
All right, great. Thank you, Kenny. So this is our 7th of 7 trainings. So thank you for joining us. If you've joined us for all the other ones, they will be available. We've recorded all of them. We're going to be working on getting them available to you if you missed any of them. They were graduated. That means that each one kind of built on each other. So we're kind of at the tail end of this with some experts joining us today. And I'm going to let them introduce themselves. I want to invite Garin back to introduce herself as well. So again, I'm the Chief of Staff and Equity at WorkSafe. And Garin, real quick.
Hi, I'm Garin Humphrey. I am a staff attorney at WorkSafe and also coordinating these series.
All right, and we'll jump to Katie.
Hi, everybody. I'm Katie Wutchiett, and I'm a staff attorney at Legal Aid at Work.
Go ahead, Daniela.
Okay, I'm Daniela Urban. I am the Executive Director of the Center for Workers' Rights. We're based in Sacramento, providing legal services to low-wage workers.
And Ruth. Unmute yourself, Ruth.
I'm Ruth Silver-Taube, and I'm the supervising attorney of the Workers' Rights Program at the Alexander Community Law Center at Santa Clara University Law School, and I also supervise the Office of Labor Standards Enforcement legal advice line that you'll hear more about later.
Awesome, thank you. So if you don't know about us, we are WorkSafe. We're a statewide organization. We work to prevent worker injury, illness, and death by increasing worker power, fighting for better and more protective laws, ensuring that the laws are being enforced, and raising awareness about occupational safety and health. You can check our website for many trainings that we do, the bills, legislation, and standards that we're currently pushing for, any trainings that you'd like, and some resources. So feel free to check out our website. That's worksafe.org. Garin is going to do a quick poll just to see who's in the room today, because we can't see you. So Garin.
Hi, everybody. So we would like to see who we have here today. I'm going to launch the poll. This helps us figure out how to tailor our content to those who are participating in our trainings. I will give people a few more seconds. Okay, so it looks like we have a lot of attorneys here today with experience. And then we also have another question where we'd like to know what you have the most experience in related to the topics we will discuss today, and you can feel free to choose more than one. I have now launched the poll. Give people a few more seconds, try to get to about 80% of you. Great. So we have a lot of people here today that have employment law experience, organizing, and also here to learn. Thank you so much for coming and participating in these polls. Thank you.
All right. Can you guys still hear me?
Yes.
Okay, awesome. Getting some weird notes from my computer. So I really wanted to take a quick moment to talk about what's going on right now in terms of the wildfires. I myself drove up and down from Oakland to Sacramento and drove through the fires. The freeway was on fire. So I want you all to be careful out there. Take note of the air quality index, which looks like this today. There's fires kind of raging up and down. The air is very unhealthy for many people. Make sure that you're wearing the correct mask when you go out, and that you are protecting yourself if you're indoors as well in terms of ventilation, not letting the air come into your house. I wanted to reemphasize, so this is a training we held maybe I think it was last week or the week before, that studies have shown that wildfire smoke can have several effects on your health, including irritating your eyes, interfering with the way that you're able to breathe, including having coughing, chest tightness, or shortness of breath. Can also lead to other health injuries and illnesses, so please be careful. We have three kind of things going on. We have COVID-19, we have indoor heat for many of you who have to work from home or are inside, and now we have to keep the windows closed, and we have wildfire smoke outside. So just please take care of yourself. Take a moment to just be aware and note what's going on. WorkSafe has been pushing hard for a permanent wildfire smoke standard in addition to an indoor heat standard, and we've also introduced the emergency temporary standard for COVID-19. The temporary wildfire smoke standard has been extended to expire in January of 2021, but today, probably as we speak, we're pushing for it in the standards at the standards board today. And these are some of the protection it has. If your workplace should have a similar kind of like injury and illness prevention plan or safety plan that involves what to do if wildfire smoke, if you're exposed to wildfire smoke in your workplace, and that unfortunately right now is in many of our homes, working from home. So what you can do to support this, email us if you want to submit a support letter for any of the three standards that we're working on. As I said, we're working on the wildfire smoke today and the emergency temporary standard, but we'll be pushing for all of those in the future. So today the goals are to give you an overview of COVID-19 and its intersection with unemployment insurance, paid sick leave, workplace retaliation, and the right to refuse. So with that, I'm going to pass it over to our presenters to jump in.
Thank you, Jora. I'll kick us off by talking about unemployment insurance benefits. We're just going to do some quick overview of the basics of all of the laws, and then focus more specifically on some hypos and variations of those hypos, so you can see how they interact with actual workplace situations. So we rely on unemployment insurance benefits for a temporary wage replacement when employees lose their job through no fault of their own. So typically in regular times, those benefits last 26 weeks. There's an additional pandemic-related extension called PEUC for an additional 13 weeks of benefits, as well as what we call the Fed Ed extensions, which apply when the economy has a high unemployment rate. So we currently have our first Fed Ed extension for additional 13 weeks of benefits as well. So the unemployment insurance benefits, or what I often refer to as regular UI, are for employees only. So these do not apply to independent contractors or business owners. And it is a wage replacement that is based on the income from your employment in the prior 15 to 18 months, what we call the benefits year, the base period year. So that's how it's determined how much you will receive in benefits, the maximum of $450 per week and a minimum of $40 per week. Now, through the pandemic unemployment compensation, the additional CARES Act funding that was approved by the federal government, there was a $600 per week benefit added on to that minimum benefit or weekly benefit amount between April 4th and July 31st. And that is what allowed people to get increased benefits. In addition, through the executive order from the president, there's an additional $300 of potential eligibility added on to benefits in the future. We just heard, I believe yesterday, that California will try to take advantage of that extra $300, but we're still awaiting details as to the specifics of when and how long those extra $300 benefits will apply. Now, in order to access unemployment insurance benefit, the separation from employment must be a no-fault separation. It can be a layoff, which is either temporary or permanent. It can be reduced hours, or you can have quit for a good cause. For example, caregiving obligations or fear of one's own health. So moving into the next slide, we learn about the continuing eligibility requirements. So not only do you have to become eligible for unemployment based on the initial separation from employment, but you also have to demonstrate to the Employment Development Department, the agency that oversees this program, that you continue to remain eligible for unemployment. So typically that includes a work search requirement. You must continue to search for work while on unemployment, but that's been waived due to the pandemic. It began to be waived at the start of the pandemic in March, and so far that has not been, it still continues to now. They still have a waiver for the work search. Everybody who is on unemployment, though, must be able and available to work. So this includes having continued authorization to work, so immigration status must remain valid. So for if you are a DACA recipient and your DACA expires, you will no longer be eligible for unemployment insurance. You'll also not be eligible if you contract COVID or are unable to work because you're caring for someone with the virus. Katie will talk about the programs that you would be eligible for in that situation, but unemployment, regular unemployment would no longer be available. Because there is this job search requirement, you're not allowed to refuse offers of work without good cause. And the HIBOs will talk more about what the good cause would mean. You also need to report any income earned. For regular unemployment, that is income when earned and not when paid. So anytime you're working in a particular work, even if you haven't received payment, you will be paid for that work. You need to report it on your continuing claim forms, your certifications that are required to be submitted weekly to EDD in order for EDD to subtract the amount from your benefits that you've earned. And you can earn above your weekly benefit amount up to either $25 or 25% above your weekly benefit amount, depending on which is greater. So if you're at the maximum benefit amount, you'd be able to earn up to $600. We also want to make sure we talk about the Pandemic Unemployment Assistance Program, or PUA. This is the special program from the federal government during the pandemic that allows those who are otherwise not eligible for regular unemployment insurance to be able to access wage replacement benefits. So this includes independent contractors and business owners, but it is limited to those who have a pandemic-related reason for not working. So unlike regular unemployment, where you could have lost your job for any reason and be able to access benefits as long as it was no fault, the Pandemic Unemployment Assistance Program requires you to verify that the reason you're not working is related to COVID. So we have here the specific requirements. The federal government has indicated exactly what situations qualify for a PUA. And some of these will overlap with those that Katie will discuss regarding the COVID-related situations. So we talked about in regular UI that if you are providing care for someone who has COVID, so you're not working as a result, you're not eligible for regular UI, but here we see that you would be eligible for PUA, as that is one of the PUA conditions. Same with being diagnosed with COVID or seeking a diagnosis. You're typically under regular UI, you would be considered not able and available, and you wouldn't get regular UI, but you would qualify for pandemic unemployment assistance. Moving on to the next slide is the remainder of the reasons that that you need to certify for pandemic unemployment assistance. So we often get questions about those who were supposed to start a new job but were unable to do so during the pandemic. And there is the ability to get pandemic unemployment assistance for these workers. However, they must have actually had a scheduled start date. So being close to being hired prior to the pandemic is not enough, but actually not being able to reach their place of employment as a direct result of COVID, and that's the reason they were unable to start, that would qualify them for PUA. Another one that we're seeing sadly more of is if someone has become the new head of household as a direct result of COVID. So if a partner has passed away as a result of COVID-19 and someone who had previously not been working because their partner was the wage earner, they then become eligible for unemployment as under the pandemic unemployment assistance. We'll move on to the next one. And I'll turn it over to Katie.
Okay, great. So there are a handful, to say the least, of laws that will protect people's jobs when they're not able to work for reasons related to COVID-19 or their health or their family's health. So I wanted to start by just doing a quick overview of some of the most useful laws that already exist and generally cover when people have serious health conditions or family members are sick, and then also dig into what some of the new protections that have been added on since the pandemic started. Because you'll see that, you know, some of the additions are great and they fill some of the gaps, but there's still a lot of gaps where people should be protected and they might not be. So these are the laws that kind of generally it's worth being aware of, and we'll dig into some specifically right now, and then other ones we'll talk about more as we go through the scenarios and kind of apply this law to see in the situation what is it that somebody can actually do. Next slide. So I think the biggest one to be aware of is the California Family Rights Act, which is the state version of the FMLA. So I'll always refer to the CFRA because it's like a little bit better, although substantively they're basically identical. So they're very strong protections in that they provide 12 whole weeks off where somebody's job is protected and their employer has to continue benefits. So this is a really important protection, but it's also very limited in who can access it right now. So it's time that can be used if you have a serious health condition, if a family member has a serious health condition, or if you have a new child that you adopted or was born within the last year that you want to spend some time bonding with. But unfortunately, it only applies if your employer has at least 50 employees working within 75 miles, you've been working for your employer for at least a year, and you've worked 1,250 or more hours within the last year, which averages out to about 25 hours per week. So with those different restrictions piled on, it's about 45% of workers who are left out. And while there are some other protections that kind of fill in the gaps if somebody has their own disability or is ill, up until the federal government acted back in March, there were no other protections for taking care of family members. So still to this day, you know, if your partner has a heart attack, your kid gets hit by a car, your parent has a stroke, if your employer has fewer than 50 employees, once you burn through your, you know, maybe only 3 paid sick days, your employer can legally fire you. So this is an important protection. It has lots of gaps. There's a bill going through right now called SB 1383 that would fill in a lot of these gaps and move that employer threshold down to 5 employees. And it would also expand the family members that are covered under this. So the family members you can take time off for are only a minor child or a dependent child or a parent or a spouse. So it leaves out grandparents, siblings, in-laws, grandchildren, lots of important family members. Some of these would be added on with SB 1383. So again, call your Congress member if you want to. But this is a protection worth knowing about. And in the context of COVID, COVID generally can be considered a serious health condition. So it's a way you can get protection for that time off. But if you don't actually have COVID and you haven't been diagnosed with COVID, or you're not experiencing symptoms, chances are you wouldn't qualify. So we'll get more into the details later on, but that's kind of the basics of the CFRA. Next slide, please. Another important protection I want to highlight is the California Family School Partnership Act. So this is one that I'm guessing most of you haven't encountered before because it doesn't come up that frequently, even though people need it all the time. But what it does is it allows someone to take up to 40 hours off in a year where their employer doesn't have to pay them, but they do have to hold their job and can't treat them any worse for taking that time off if they need to enroll their child in school or daycare or attend a school activity. But in this moment, specifically, also if there's a school or childcare emergency, meaning that it's closed and the child can't be taken to school. So like last year when there were the fires, we were putting out information about this because, you know, if school's closed, this was an important stopgap. This year, schools have been closed and will continue to be closed and unavailable for a long time. So it's not what we need, but it's what we have. Next slide. So we also wanted to dig into the Families First Coronavirus Response Act. So this was like the big federal fix to let people get paid and prevent them from being fired if they had coronavirus or their family member did. So it started in April. Right now it's only going through the end of this year, and it only covers employers that have fewer than 500 employees. I think the theory was that all large employers already provide these protections, so everything's fine. They don't though, and this is a huge exception, and only about like 20% of workers might actually be covered by this. But what it does is it allows a person to take 2 weeks off with pay and their job protected if they either have symptoms of COVID and are seeking a diagnosis, if their doctor specifically has told them to stay home or quarantine, or they're subject to like an isolation or shelter in place order. So it doesn't have to be specifically for them, it could be for the county, and then they can get 100% of their pay. If somebody has a family member who's subject to a shelter in place order and needs care, or is sick and needs care, someone can take the 2 weeks off and get 2/3 of their pay, up to $200 per day. But importantly, if the reason someone is not able to go to work is because they have to provide care for a child who would normally be cared for by somebody else, but because of COVID, that other care isn't available. And so that could be a school is closed, a daycare is closed. It could even be that the child is normally taken care of by a grandparent, but it's not safe for the grandparent to continue to provide care. That person can take 12 weeks off with their job protected and receive 2/3 of their pay. So it's 2 weeks for your own illness, for family members' illness, but 12 weeks for childcare. So one of the things you might see as we go forward is, you know, even if like the reason somebody's like, okay, I need time off from work, if the reason that's occurring to them isn't childcare, it might be important to ask, okay, do you have children who need care? You know, could this be a reason that you need leave? Because it does have that longer protection. Next slide, please. And with that, I will pass it off to, I think Jora is going to take it.
And
Yes.
then I'll cover retaliation.
Okay, great. And so we've, since COVID-19 has started, we've received a lot of reports from workers who feel like they're being made to work without the proper protection, whether that be PPE in the form of masks and gloves or some other kind of protection along the hierarchy of controls to limit or minimize or get rid of, prevent the exposure to COVID-19. So I wanted to cover the right to refuse work. We also sent you our FAQs or fact sheet in Spanish and English, and we have one in Vietnamese that will be coming out shortly. So under California Labor Code section 6311, employees who are asked to do dangerous work can refuse if the employee knows or believes that doing the work creates a real and apparent hazard, a health and safety hazard for themselves or their co-workers, and the employee knows or believes that it's against the law according to the labor code or a Cal OSHA order, standard, or regulation. The guidance is not listed in section 6311. So many of the guidances that have come out from Cal OSHA with regard to COVID-19 may not be covered under the right to refuse. So what is a real or apparent hazard? Oh, and before I get to that, I did want to point out that if there is someone wants to engage in the right to refuse, it's actually the labor commissioner that enforces it, not Cal OSHA. What Cal OSHA can do is protect the right to refuse in a workplace, that is enforce it. I mean, reiterate with the employer that this is something that the worker has the right to do. However, if a worker does engage in the right to refuse and then gets retaliated as a result, they must then file a complaint with the labor commissioner, who is Lilia Garcia Brower. So this is something that's very confusing to advocates and workers, because if they're dealing with Cal OSHA on a health and safety case and they get retaliated against, they expect the inspector with Cal OSHA to continue to assist them, but actually they have to go and file a whole other case with the labor commissioner. So just note that. So the definition of real and apparent is on a case-by-case analysis. In looking over the guidances that Cal OSHA has provided for COVID-19, it is not discussed anywhere. Nowhere does it state how the right of refusal comes up. In meetings with Cal OSHA, Doug Parker, the chief, has stated and I believe he also stated in his Facebook live session that workers have the right to refuse. However, he didn't apply it directly to COVID-19. So what Doug Parker has told WorkSafe is that if you have a situation that you believe is a real and apparent hazard, consult with Cal OSHA. Give Cal OSHA a call and talk to them first, and kind of discuss with them what your issues and rights are. The only scenario that WorkSafe believe counts as a real and apparent hazard, and again, we don't know how this will play out, because in order to actually see how it plays out, you have to file a complaint. Cal OSHA has to come in and then do their inspection and then make a determination. And to the best of our knowledge, we haven't seen that yet. It takes Cal OSHA 6 months to do an investigation, come out with citations, and COVID, the stay-home order started, in late March, I believe, and so 6 months to late March might have been when complaints started to get filed. So we won't see the results of any complaints until late summer, early fall. So as of right now, we believe that the only situation where there's Cal OSHA may consider there to be a real and apparent hazard is when an employee is directly exposed to a confirmed COVID-19 infected individual or their bodily fluids. So for example, a person coming in to clean a room or a bed or hospital area without the proper safety protections, and there was an individual who would confirm COVID-19 in that room beforehand. If a worker does feel that they need the right to refuse, we recommend 8 steps to do so, and I'm just kind of going to brush over those very briefly, but feel free to call us if this is something you're looking at, not just for COVID-19, but for any kind of health and safety hazard. The first is always to document and keep notes of everything that's going on. Try to have a good body of evidence, basically, if you're going to engage in the right to refuse, because if a worker gets retaliated and has to file a complaint, they want to, you want to have a body of evidence to point back to. Talk to trusted coworkers to see if they're also getting sick or if they believe the task is unsafe or unhealthy, what's going on with them. So just kind of feel other folks out in the workplace. Consult with Cal OSHA. This is specific to COVID-19 to see if the hazard breaks the law, but any other hazard as well, and ask Cal OSHA for their kind of advice on what the worker should proceed to do before filing a complaint, like how they can mitigate it, what they can do in the workplace to make things better. Engage a union or a worker center. If there's no union, if the worker's not represented, then see if there's a local worker center in the area. Contact us, WorkSafe or SoCal COSH if you're in the Southern California area. Prepare to talk with your supervisors. So steps to prepare include seeing if you can act when others are around so that you can have witnesses. Refuse with others so that you're not doing it alone, so that you engage concerted activity in the protections under the National Labor Relations Act for engaging with other workers. If you have a union representative, have them come with you and take notes. Again, documentation is very important. So when it's time to talk to your supervisor, we want the worker to explain that they think the job or task is a hazard to them and others. We want them to be able to give maybe some ideas of how it can be fixed if they know. If not, ask that it be fixed and request a timeline for when the employer will fix the hazard with a solid deadline or timeline. Follow up the discussion with the supervisor with a written confirmation letter and a note to document the discussion. And number 6 is if that deadline comes or that timeline comes and the employer has not done what they need to do, then that is the time for the employee to inform their supervisor that they're going to exercise their legal right to refuse. And we want the worker to tell the employer that we're doing this because the worker is doing this because they know or believe that working will be a hazard for themselves or for others, that the hazard violates the law, labor code, or standard or guidance, but we're not sure of the weight of those guidances. And tell the employer, hey, I'm willing to do something else in the meantime that you're fixing this hazard. And call the local Cal OSHA office to make a complaint would be the step 8. And so give us a call if there are workers who are interested in exercising this right, so that we can kind of get talk you through more of the nitty-gritty of it. All right. And
so I did want to talk a little bit about retaliation, and I wanted to point everybody to the handout that you were given, which is called Retaliation is Illegal, Know Your Rights. So the first right you have is a right to the following COVID-19 related protections, and you can't be retaliated against for number 1, if you complain about exposure to coronavirus in the workplace, if you complain about the lack of personal protective equipment, and if you complain about employer policies related to reopening requirements. Labor Code 6310 protects you for complaining about health and safety. And as Jora said, you have to file your claim if there is an adverse action, if your hours are cut or you're fired. You have to file that with the Labor Commission. The Labor Commission will look at whether there's a nexus between the adverse action and the complaint you made as well. And so that's important. Now, the Labor Commission analyzes this under Labor Code 98.6 and 1102.5. 98.6 says that if you complain about something in the labor code and there's an adverse action and damages, then you will get $10,000 for each adverse action. It's also an 1102.5, which generally is the whistleblower statute that says that if you complain about anything that violates a federal or state law, you can file a claim. And for 1102.5, the 10,000, there is 10,000, but it's only for an LLC or corporation, but you can use that when you bargain. Of course, if you're terminated, you could file wrongful termination in violation of public policy. Also, I wanted to repeat a little bit about what Jora said about the best practices. And it is really important to identify what law and what hazard there is and communicate it, document who, the date, the time, what was said, and send a confirming communication via text, and also witnesses. Witnesses are really important in every type of retaliation claim or any other kind of claim you have. So really keep in touch with employees that were there, but also former employees who were there or who had this happen to them are really good witnesses. And then talk to an advocate and file a timely claim. So finally, I want to talk about immigration retaliation, and that's also on this form, unfair immigration-related retaliation. Basically, Labor Code Section 1019 protects you from threats to call ICE or threats to call the police if you complain about something that violates the labor code, like wages or health and safety. And in addition, as it states here, an employer who does this, this is also in the labor code, so it's also a 98.6. So it's, as it says here, it's $10,000 per threat. But also the employer under Business and Profession Code 494.6 can have the license suspended, and as it says on this sheet, it's 14 days for the first violation, 30 for the second, and 90 for the third. And finally, attorneys, we have had attorneys have these threats and letters. Business and Profession Code 6103.7 makes it a cause for suspension, disbarment, or other discipline if an attorney threatens to report the suspected immigration status of a witness or party to a civil or administrative action. And then, as Jora mentioned, it's important to think about protected concerted activity under Section 7 of the National Labor Relations Act. And that's not only if you complain with others, but if you complain on your own, but on behalf of other people.
Okay, and are we ready to move on to the next slide?
Yes.
Thank you, Ruth.
So with that, we'll start with talking about our hypotheticals. So we're kind of going to build stories and offer alternative scenarios. So you don't have to remember too many details because we'll take it in pieces. So we're going to start by talking about workers who themselves been exposed to COVID. So James, a bakery worker, works at a bakery with 20 employees. In April, while the bakery was still in operation, he learns he's been exposed to COVID-19. So we take a look at his available rights and remedies if he wants to take off time to be tested and quarantined. So in each of these slides, we're going to look at wage replacement, job protection, and retaliation. I'll start actually at the bottom of our wage replacement column with California paid sick days. California provides generally 3 paid sick days to all employees. You start accumulating these paid sick days based on the number of hours worked after 30 days at your employer as well, and then you're able to use them after 90 days. There's also a provision that reinstates these paid sick days if you're laid off and brought back to work. So during COVID, if an employer temporarily closed and lays off its workers, if you are brought back, you'll still have your paid sick days. So we generally use those as our first line of defense for those who've been exposed to COVID because they're both for prevention as well as treatment of an illness. So while you're still looking for a place to be tested or awaiting results or those early days after you've been exposed, the California paid sick days are often your best option. Also, because they've been around since 2015, more employers are aware of the employee rights to California paid sick days. They should be appearing on your pay stub. Your accrued paid sick days should either be attached or are part of your pay stub, so you should know how many you have. So that makes it easier for workers to be able to take those paid sick days right away. If you're not getting your California paid sick days, the enforcement mechanism is through the California Labor Commissioner's Office Wage Adjudication Unit. You can file for both the unpaid sick days as well as the failure to document the number of days accrued. So because it's a California law, it's California enforced. So as we talked about in the overview, pandemic unemployment insurance is also available if you are if you have symptoms and are seeking a diagnosis for COVID, or if you're subject to a quarantine by a public health officer or medical professional, you'll be able to access pandemic unemployment insurance. Now, this is both for employees as well as independent contractors, because as we talked about, if you're not able and available to work, you're not eligible for regular unemployment, but only the pandemic unemployment insurance, which you can access through the Employment Development Department, the same application as regular UI. And so that is how you can also receive wage replacement through a state program. So it's not paid by the employer, but through the state benefits. And then I'll turn it over to Katie to talk about FFCRA.
Great. So one thing I'll throw out is, I know in these columns we talk about like wage replacement, and then we have a separate column for job protection. We do that because in California there are like a number of programs that protect your job but don't pay you, or pay you but don't protect your job. But fortunately, we're seeing like more of the new protections that are coming into place during COVID actually do both of those things. So if you see it in both columns, it's because it did both. It was intentional and it's a good thing. One note I'll make about paid sick days is that a number of localities have their own paid sick days laws too that offer greater protections. So if the workers in a city where you think they might have more protection, so think like, you know, San Francisco, Oakland, Emeryville, Los Angeles, I know there are others, it's worth looking it up because you might have access to like 5 days or 7 days instead of 3 days. And so that ties into the time off that you can get under the Families First Coronavirus Response Act also. So that law was very explicit that the days that it provides are on top of anything that the employer already offers. So if you have 3 California paid sick days, the FFCRA gives you 10 extra days, so you have 13. Your employer can't count those 3 days towards that total of 10. And so, like we talked about, you know, these are available if you have an employer that has fewer than 500 employees, and if you think you might have coronavirus, you've been exposed, and you're seeking a diagnosis. So an employer can't require a medical note saying you have COVID. They can ask for information of like what doctor you're seeing or something like that, and you can provide that, but they don't get to say, okay, you need to provide a medical note or you can't take time off. So this time can't be held against you. The employer needs to pay it out of their own pocket. And one thing to keep in mind, if there's any pushback from the employer, is that the DOL has actually been pretty good on following up about this. So if somebody takes this time off and then their employer tries to say, okay, don't come back, or an employer might only try to pay for a week of it, or say you need to provide a diagnosis to get paid. I could go on with the things that we've seen, and I'm sure you've all heard as well. But feel free to call the DOL and people can make a complaint, and then the DOL's done a pretty good job of like calling the employers and explaining, hey, you know, you have to provide this. One other thing I just want to throw in is there's a misconception out there that employers that have under 50 can be exempt from the FFCRA. They can only be exempt when it comes to providing leave to care for a child. So for your own illness, to take care of sick family, there is no under 50 exemption, even though lots of people are trying to claim it. So I think that kind of covers the basics in the situation.
And these laws have retaliation provisions as well. So you would go back to the DOL if you were retaliated against, and you should follow the steps we talked about, documenting, are there witnesses, etc. And the DOL, they do answer the phone, and it's not like unemployment, and you normally can get through to someone, and they have been following up.
And I just wanted to add too, there are local ordinances regarding the Family First Coronavirus Protection Act exemption of 500 or more. So in this hypo, we stipulated to a small employer, but if it is a business of 500 or more, there are local ordinances that have helped implement that, as well as protecting against retaliation.
Yeah, the city of San Jose, if you worked there, there's no exemptions, even for over 500, and I think there's other cities as well.
And for food workers, there's an executive order that covers the whole state. So that's people who deliver food for DoorDash, people who work at like Targets that sell food, people who work at restaurants. So there is kind of like a patchwork filling in about the 500.
So for the next slide. So for James, after 2 weeks, he recovers from COVID-19 and is ready to go back to work. But his employer is not requiring employees to wear masks. So what are his rights in this situation? So whereas before we had said that he could be eligible for pandemic unemployment assistance, we would now suggest that he transition to regular unemployment assistance. When workplaces are unsafe, workers are found to have good cause to refuse work if they have a reasonable fear of their physical or mental well-being. And this is an objective standard. So as long as that, or subjective standard, as long as that person has their own reasonable fear, they're able to refuse that work. So this is a very different standard from what Jora was talking about in terms of the ability to refuse unsafe work. The standard for unemployment insurance unsafe is much of a lower bar. And so while an employee may not have job protection, they would have the wage replacement available under unemployment insurance. Now for James, transitioning between pandemic unemployment assistance and regular employment is very difficult given our current state of EDD. Once in a program, it's very difficult to switch programs. So even though the law requires that we go for the, between the UI and the PUA, it is not easy in sort of a practical sense.
Daniela,
I don't have good tips.
Daniela, you're breaking up a lot. I'm not quite sure. I think we're missing a lot of what you're saying. But I'll jump in real quick while you're figuring out what's going on. I think Daniela is going to try to call in on a phone. She had like a backup plan. And so exactly what Daniela was saying regarding the right to refuse, that relates to unemployment insurance. However, with respect to Cal OSHA and the right to refuse work there, anytime you refuse work, you run the risk of retaliation, and that is just that's just the state of vulnerability in terms of workplaces. And so here in this situation, if James feels like he needs to refuse work because he's feeling unsafe, nobody in the workplace is wearing masks, the best course of action is to call Cal OSHA first and kind of assess the situation for Cal OSHA. I have not seen in this fact pattern anything to indicate that there are positively confirmed folks with COVID-19 in this workplace, or that James is engaging with anyone who has tested positive for COVID-19, is an infected person, and is therefore contagious. And so, based on what we believe is a real apparent hazard, I don't see a situation here that Cal OSHA may define to be real and apparent, and the Labor Commissioner would then be able to protect James if he was retaliated against for refusing work.
And if he did go back to work and he complained about the masks, then, and he was either terminated or his hours were cut or there was some kind of retaliation, then he'd be complaining about health and safety, which is that Labor Code 6310, but the Labor Code looks at it as a 98.6, which is that you are complaining about something that violated the Labor Code. And so therefore the $10,000 plus, of course, your back pay, and you would get your job back. So that would be there. And also the 1102.5, which is any, because if it's in the Labor Code, it's also any law that is any state or federal law. And so therefore it's that too. And even though the money doesn't go to you, the 10,000 or your client, if it's an 1102.5, if there is an LLC or a corporation, it gives you good bargaining power because the employer is going to have to pay, or at least leverage if you're trying to negotiate, or even have them settle the claim. So that's important. And if he complained with a lot of other people or himself on behalf of others explicitly, then you could bring the National Labor Relations Act, protected concerted activity for violation of Section 7. And again, reiterating, I get so many people that just verbally complain and then the employer says they never complained. So either if you do it verbally, send a confirming letter, or if you do it, better yet, do a text or write it. And please keep track of witnesses. And of course, management supervisors, even though they seem to be supportive, they're not going to be witnesses for you.
Oh, and can I just real quick before Katie jumps in, clarify that exercising your right with respect to telling the employer that there is a health or safety hazard is protected, but walking off the workplace and then getting retaliated against might not be protected just because of the whatever is defined as real and apparent. So just the very act of raising awareness with the employer that there are COVID-19 risks, that is a protected exercise of occupational safety and health.
And I did want to add that it doesn't have to be true when you complain. You just have to reasonably believe. And if you're refusing work, it actually has to violate a law. But if it's if you're just complaining, as long as you have a reasonable belief. And we've had cases, we did some investigations for the Labor Commission where the person was dead wrong, but it was buried in the statute and it would have been hard to find for a layperson, and the Labor Commission did find that it was reasonable. They had a reasonable belief that they had that right.
Okay, thanks. I'm going to ask us to go back a slide. We accidentally skipped one. So I want to make sure we talk about what happens if someone actually has COVID. So if somebody actually is diagnosed with COVID, a lot of the same protections apply as if they're quarantining or if they're trying to be tested. So, you know, they would still be able to get paid sick days. They would still be covered under the FFCRA. But this is when it's important to also pay attention to like the pre-existing serious health condition and disability focused rights that we have in this state that people might not know about. So as far as income goes, if somebody's out of work and it's because they have COVID, they can try applying for state disability insurance. And so this is a really great program because it's something where immigration status does not matter, and it provides 60 or 70% of what somebody would be making if they were working. And so during normal times, it's a lot more money than you can get from UI. When the bonus money is thrown on top, you have to look at the two and decide. But generally, it's a pretty good deal. And it's something that workers pay into out of every single paycheck. Some money goes to the EDD to this fund. So when they apply for it, it's only their own money that they're getting back. So employers generally are not going to oppose it because it doesn't cost employers anything. It doesn't cause their UI contributions to go up. It's just that workers' money that they're getting back. A medical certification is required, so that's an important thing to keep in mind. And most healthcare providers have the paperwork on hand. And then on top of that, as far as taking time off and making sure that your job is safe, like we talked about, the FFCRA gives 2 weeks, but that might not be enough for everybody. So that's when you would want to look to the California Family Rights Act, which can provide up to those 12 weeks, assuming that, you know, this bakery has at least 50 employees within 75 miles, that he's been working at least an average of 25 hours per week, and that he's been employed there for a year. If any of those things are not true, it doesn't mean that his employer is allowed to legally fire him. You can still ask for time off as an accommodation for a disability. To talk about it in the disability scenario, you'd have to have a pretty serious case of COVID. You know, it couldn't just be like a cold or a flu, but if it was something that caused somebody to be hospitalized or was lasting for a long time, that would be a good basis to make a request to the employer for time off as a reasonable accommodation for a disability. And as long as the employer has at least 5 employees, they have to respond to that employee's request and either provide that accommodation, meet and talk with that employee and engage in, it's called an interactive process, to see what is an accommodation they could give that would allow him to recover and come back to work. Or if they want to deny it, they have to show that it would be an undue burden on the employer to provide that time off. So if it's only like 3 weeks or 4 weeks, it might be difficult for the employer to show that, you know, this is just so hard that they would have to shut down their business and have to say no. But, you know, it gets complicated. So if any of that comes up, especially if somebody works for an employer that has fewer than 50 employees and they need more than 2 weeks off, it's always helpful. I always recommend giving us a call or giving somebody else a call to learn more about that disability accommodation process.
And
Sorry, just throw in before, Ruth, before you go into retaliation, the only upside of pandemic unemployment insurance over state disability, besides what Katie described in terms of the amount of money, is that it's a self-certification for eligibility. So you don't need to submit the doctor's note in order to get pandemic unemployment insurance for if you are diagnosed with COVID.
I did want to say for state disability, if any of your clients or anyone you know is undocumented, the form, and I've talked to people that work over there, unfortunately it does have a field for Social Security. So what to do is to request a paper form and just leave that blank, and they'll ignore it. So, and for retaliation, FMLA, CFRA. The CFRA you file at the Department of Fair Employment and Housing, and there's a retaliation provision, so you go back to the Department of Fair Employment and Housing and you file a retaliation claim, or if you file after, then you just file both. Same with FEHA, if you're requesting accommodation or there's a failure to engage in the interactive process, which is that dialogue, you go back to the Department of Fair Employment and Housing, or you file at the same time. It's really important that you also file retaliation. And the reason there isn't one central agency you go to for retaliation. It's these agencies that are really interested in no retaliation if people are trying to assert their rights. And so therefore they take those claims. Statute of limitations now for fair employment and housing has been extended to 3 years for Department of Fair Employment and Housing for CFRA and Fair Employment and Housing Act claims. But for retaliation, I did want to say at the Labor Commission, if you were asserting your right, some sort of like if you were complaining, let's say about health and safety, I do want to flag the fact, which is that the statute of limitations currently is 6 months under AB 1947, which has a really good chance of passing and being signed by the governor, because we initially asked for a 2-year statute, and he said if we came back with 1, he would sign it. But it's right now it's 6 months. Also, if you go to the NLRB for protected concerted activity, those are the former slides, then it's also 6 months. So we've had people that have come in past the statute and are out of luck. And the statute, if you complain and are fired and go to court, wrongful termination in violation of public policy is 2 years. But the protected concerted activity, you have to go to the National Labor Relations Board.
So 2 small things I wanted to throw in, and then I'll let us continue because I know time is short, is one, so rumor has it the DFEH is fast tracking COVID and coronavirus related cases, and they identify them by like doing control find on complaints. And I'm not sure what exact words they're using. So if you're making a complaint, I would say like, I have COVID-19/coronavirus and like throw in the different terms that mean the same thing, just so that you can be caught up in their system and you might get an interview faster and get the DFEH to act more quickly. And then I see we have a question about whether an employer can require an employee to provide proof that they took a COVID-19 test. So they're not required, an employer is not allowed to require a COVID-19 test. They can ask for the doctor that you're seeing, or for like the California Family Rights Act, something saying like from a doctor saying you have a serious health condition, but it doesn't have to say what that health condition is. And as far as returning to work, I think that'll come up in one of the scenarios we're looking at later. So good question.
And then there was another question I think asked, a while ago, so I'm unsure of what it refers to. So hopefully you can figure it out, but does the Food Worker Act cover farm workers?
Oh, that's a good question. I think it does. Let me check and I'll answer later on in this, but I'm pretty certain.
Okay. And then there's another question as well. If a worker is forced to sign a mandatory arbitration agreement, can they go to court if they're retaliated against?
If they have to arbitrate, they're going to have to arbitrate all claims, but the Labor Commission makes them go to court, typically to compel arbitration.
Okay, great.
We already covered that one. Excellent. Okay. So if an employer, so in the bakery situation, still talking about James here, the bakery then closes because of lack of business. So, after such a rough time, James having COVID, his employer has now called it quits and is temporarily closing. So James, in this case for wage replacement, would remain on UI if he did in fact refuse to go back because they didn't have masks, or if he did end up going back to work, then and was only on PUA before that, then he would then apply for regular unemployment insurance. So due to layoff, he can file for unemployment and receive between $40 and $450 for that time period. So if this happens while he's still sick, so if he hadn't quite recovered, then he would be able to remain on SDI until he recovers, and then he would switch to UI.
On the job protection front, if somebody's laid off and it's for a legitimate business reason, they're laying off other people and they're not specifically targeting this person, generally your job is not going to be protected. While you have the right to these different types of leave, they give you the right to be treated the same as if you weren't taking that time off. They don't give you like a heightened privilege among other workers who are continuing to work at that time.
But if the employer only lays off the workers who complained, and I've seen that recently, then you would have a retaliation claim.
Great. I think with that, it was a quick hypo, so moving to the next. Okay, so we want to make sure we touch on what happens if James is undocumented, whether that impacts his rights under any of the scenarios that he's been through. So in terms of wage replacement, regular unemployment insurance as well as PUA is not available to those who are undocumented. And that's because they're not considered able and available to work. And so none of the provisions that we talked about where we suggested unemployment insurance or pandemic unemployment would be available. However, the state disability, as Ruth mentioned, is still available, even though also administered by EDD. It's still available even for those who are undocumented because workers themselves have paid in. So often people say, oh, I'm not eligible for EDD benefits, but you want to make sure you clarify with them whether they're looking at applying for SDI because they themselves have COVID, or whether they are talking about unemployment insurance because they have separate standards. I'll turn over to Katie on the FFCRA.
Yeah, I'll speed through. Basically, any right to leave is the exact same, including the right to get paid by your employer. And as we said, the right to get SDI, it's the same also, although the process can be a little more intimidating. So if anybody has questions, they should feel free to reach out. But the EDD also put up on their website, it says like immigration status does not matter in bold. So that's something that can be good to share with people too if they're feeling nervous. That's it.
For retaliation, I mentioned Labor Code 1019. It's an unfair immigration practice, but they analyze it under 98.6 for the 10,000. And we've had cases where there's been 3 different threats, one to the person, then they went to the cousin's work and to the husband's work. So that was 3, and that was $30,000. I did, yeah, so I think that's really important to know about now. We did have one client who was actually deported to Mexico. We did get him money, and we did get the money to him. So sometimes employers will report, but we haven't had that in other cases. And as I mentioned, there's also the Business and Professions Code where there's disbarment, and then there's the business can be closed for 14, 30, or 90 days for the first, second, and third time.
And I just wanted to mention on the question in the chat, I was just trying to answer as well. If an undocumented worker contracts COVID on the job, can they still apply for SDI and receive those benefits? As Katie answered, yes, they just leave the social security number blank. But I want to also clarify that we're not talking about James' scenario. He did not contract it at work. I believe WorkSafe already did a panel on workers' compensation. So we're not talking, in our scenarios, we didn't talk at all about workers' compensation. If they contract it at work, They would be in the workers' compensation world of laws, which is a whole nother area of law, which is also available for undocumented workers. But just to differentiate James, who was exposed to it but not at work, or doesn't know, we didn't make it clear, and those who actually get it at work.
I did want to point out, and I don't know if this was pointed out at the workers' comp, but this is really important, and a lot of our clients don't know that if they're taking a long time or they're disputing the workers' comp, as long as you have a comp number, you on the SDI form, you can say it said, you have a comp case, and they will pay you. They will pay you. So that's important to know, that you can apply for SDI, because there was a presumption in workers' comp, as you probably heard, and that if it was within 14 days, you would get comp, and that's gone now. So it's much harder unless you're in the healthcare field. So SDI is available to you while you're waiting, and they later sort it out if you get comp.
Great, so we'll move on to the next. So now we're going to talk about another scenario. So we're going to talk about Tina, who works at a warehouse. Then throughout April, the warehouse reduces her the operation and reduces her hours from 40 to 20 hours per week. So what does she have available to her for those reduction in hours? So moving to the first slide. In this scenario, we're basically only talking about our wage replacement, because she continues to be working, and it was the employer who did the reduction in hours, so we're not really looking at any job protection or retaliation scenarios. When hours are reduced, there is the potential to be eligible for unemployment insurance. In regular time periods, you have to fill out a notice of reduced earnings that the employer needs to provide, but that's been waived during COVID. However, based on your rate of pay, that's what determines the number of hours that need to be cut in order for you to qualify for benefits. So if you're a high wage earner, even if your hours are cut in half, you still will be making over that $600 per week under your weekly benefit amount. But if you're a low wage earner, the hours don't need to be cut as severely in order to be eligible for unemployment insurance. So you'll still have to report any earnings you do make on your weekly certification forms. And that, again, as I mentioned in the beginning, is in each week you earn those wages, whether or not you've been paid them or not. So if you're a worker that doesn't get paid regularly or is paid every other week, you're still reporting your wages in the week that they are earned. So Tina here would be eligible to start receiving unemployment as soon as April, when her hours were reduced. Moving on to the next. So then we're talking now about Tina and her coworker, Maria, circulated a petition during their lunchtime requesting that the employer send home anyone who shows symptoms of COVID-19. The next week, Tina only gets 5 hours of work. So here, in terms of wage replacement, we're again talking about unemployment insurance. Unemployment doesn't differentiate the cause for the reduction in hours of work. It just fills in the gap based on the number of hours that you've worked. So assuming that she's below her maximum earnings per week that she's allowed with her particular weekly benefit amount, she would still be able to receive her wage replacement benefits under unemployment.
And of course, this is classic retaliation. There was a petition. I've had a couple of cases recently where there's been petitions. So it's there's a number of people signing. And so this is definitely protected concerted activity. Section 7 of the NLRA remembers 6-month statute of limitations. But also she's complaining about health and safety. That's 6310, which is analyzed as a 98.6 and 1102.5 for the reduction in hours, because she had a adverse action and there's a nexus. Besides temporal proximity, there has to be more, and here it clearly is because of the petition.
So now we're going to look at a change in her caregiving duties. So Tina's husband gets a job with long hours. He has been the one that was taking care of the children when their school was closed due to COVID. So Tina had only been working 5 hours per week, but her employer calls her back to work full-time. What are her rights? So when we're talking about wage replacement, unemployment insurance is still available to those who have to leave their work because of caregiving obligations. Now, it can be particularly tricky to continue to receive unemployment insurance for caregiving because you have to still be able to certify that you're able and available to work. So one of the ways that we recommend that workers complete their weekly certification forms when they're getting unemployment as a result of caregiving is to imagine a scenario where they could have full capacity to control their schedule at work or work from home. And if they were able and available for that kind of work, they can truthfully answer the question that they are able and available for full-time work, even though they have caregiving duties. So in Tina's situation, let's say her husband is home for at least 8 hours a day where she would be able to have a job should her employer be able to accommodate that particular schedule. Then we recommend to our clients that then they can truthfully tell EDD that they are able and available for full-time work. If not, we tell them to mark that they are not able and available because of their caregiving obligations and then explain why. So what kind of situation they are facing that does not allow them to work as a result of their caregiving duties. Now, so far, we haven't seen anyone taken off unemployment insurance for saying that they are not able and available as a result of caregiving, but this could be an issue that EDD tries to challenge, in which case these workers wouldn't be denied any wage replacement benefits under EDD. They would actually just be moved to the Pandemic Unemployment Assistance Program. So that might potentially be the reason that EDD hasn't been challenging this differentiation yet, because EDD would still have to pay benefits. It would just be under the different program, the Pandemic Unemployment Assistance Program, which, as we discussed in the beginning, has a specific allowance for those who are providing caregiving as a result of school closures. So there is kind of that realm of unemployment insurance available if she is not able to go back to work for her employer full time. She should, in both scenarios, try to preserve her employment. And this, filters into the job protection area, but I see it mostly in terms of being able to protect her rights under unemployment insurance and pandemic unemployment insurance, because an employer has the potential to say that she has quit her job if she doesn't return to work when called back. And for a quit, EDD looks at whether you've taken steps to preserve your employment. So out of abundance of caution of EDD's determination, we also recommend that employees try to work with their employer in order to be able to work as much as possible during the pandemic if they're called back to work, but they're unable to do so due to childcare. So suggesting that they be able to work from home, suggesting that they are moved to weekend or evening shifts when they have assistance with their caregiving obligations, or other such accommodations that would allow them to continue to work before they outright refuse that employment. Then Katie, moving on to the FFCRA.
Yeah, and on the job protection front, so if the reason she can't go back to work is because she does need to provide care for a child, she does have the right to take 12 weeks off and have her job be protected. So what that means is that, anytime within those 12 weeks, if the situation changes and she wants to go back to work, they have to say, okay, you can go back to work, and they can't hold that time off against her. There's also the couple of days under the Family School Partnership Act, but those kind of like melt into the general 12 weeks under the FFCRA. Let's go to the next slide.
So if we just tweaking this scenario a little bit, asking whether her wage replacement and job protection or retaliation would be different if her doctor tells her she shouldn't go back to work because she's at greater risk of COVID because of her diabetes. Now, in terms of unemployment insurance and PUA, these both remain potentially available. For PUA, it's more clear that it's available because it is a restriction by a medical professional to self-quarantine or to limit the risk of spread by going to the workplace. Under unemployment insurance, there is this question of whether you are eligible based on this able and available standard. We take the position that if you're able to work from home, you're still able and available. So the doctor's restriction may not be a barrier to you working at all. But it is often on a case-by-case basis whether you will qualify for unemployment insurance because of your greater risk, and whether you would be able to accept suitable work and be able to document your continued eligibility for unemployment. So there's kind of this gray area between UI and PUA when it comes to the greater risk because of COVID. And I'll turn it to Katie for the SDI.
And speaking of gray areas, it's also unfortunately a gray area when it comes to state disability insurance. You're supposed to be able to get it anytime your healthcare provider says that you are not capable of working because of your health. So like generally, for example, like if somebody's pregnant and they're working around like toxic chemicals, that would qualify. But the EDD has been fuzzy on how they're treating situations where someone has a serious health condition, but it's the risk of COVID that makes them unable to work. So if you're talking with somebody, it might just come down to the phrasing of it and making sure that a doctor writes a note saying that Tina is unable to work because of her diabetes, not that Tina is unable to work because of risk of COVID. The job protection is similar to what we talked about before for James. Diabetes is a serious health condition, so if she qualifies, she could have up to 12 weeks off. If she has an employer that has fewer than that number of employees, or if she's used up her California Family Rights Act leave, or let's say she's already taken time off to take care of her kids, those 12 weeks, she could always try to take additional time under the Fair Employment and Housing Act for a disability.
And the same retaliation protections under the CFRA and the FEHA, she could file a claim if she's retaliated against at the DFEH.
We'll move to the next one. So what if she lives with her elderly aunt, and what if her, so this is 3 different situations under the same question. So living with an elderly aunt, what if that aunt has chronic bronchitis, and what if her aunt raised her? So in terms of unemployment insurance, it could be seen as a good cause quit if you leave the job entirely and are in order to protect the health and safety of someone you live with. It is not 100% clear at this time and would result in a factual investigation by EDD when you apply. So again, you want to be able to preserve your employment in order to consider it a good cause quit if you do have to leave. It would not be the same if there's no job protection in unemployment. So if it's determined that it was a quit, then you may be able to continue to get unemployment benefits, but you likely won't be able to go back. That's where we move to the job protection categories. So you, the health and safety, the fear of health and safety does apply to the spread within your own workplace as long as it's reasonable.
And so talking about the question, so we say, okay, so what if she is basically at risk? What if she has a serious health condition? And then what if she's basically a stand-in for a mother? So we're looking at serious health condition and the family relationship. Paid family leave is available if you have a family member that is a parent or in loco parentis, so somebody who raised you, and they have a serious health condition and require care. You can get up to, you can get 60 or 70% of your income. Same immigration status, doesn't matter. On the job protection front, under the FFCRA, which is the federal one that gives you 2 weeks to take care of a family member, if that family member has been ordered to isolate by their doctor or quarantine, even if it's not somebody who is like actually your parent or lives with you, you might be able to take that time to care for them if it's someone that would generally have the expectation that you would care for them. And then when it comes to the California Family Rights Act, somebody would need to have a serious health condition. So we're talking about that bronchitis as opposed to just somebody being older. And someone would need to have that parental relationship. So be somebody who raised them or not. So I know this is fuzzy, but it's just kind of questions to think about. If somebody tells you, okay, I'm worried about my aunt and that's the reason I can't work, you'll want to ask, okay, any health conditions and like, what is your relationship with this person?
So I just wanted to jump in because we are at time. It is 1:30. I want to respect people's time. I know I don't know how many more slides, a couple more slides, not that many.
Yeah, I think there's one more slide, which maybe we could just answer as like a handout that we can send to you. And the other slides include resources for legal aid at work, and also there's also a Office of Labor Standards Enforcement OLSE hotline number where attorneys speak English, Spanish, Tagalog, Vietnamese, Mandarin. Yes, you can see right there. We're on that slide. So I did want to flag that for everybody before you head out, and wanted to remind people to fill out the evaluation. And we should also give many, many thanks to our panelists who came here today and took a good amount of time out of your schedules to come here and present. And Jorah, I don't know if you wanted to add anything else to that.
Yes, I wanted to thank our captioner who's been typing away and working very hard, and also ask the panelists to just hold on a sec. We want to take a quick picture before you head off. WorkSafe has many other trainings. If you'd like to find out, please log on to our website. We also have many coalitions, not many, but a handful of coalitions that is working to address workers' issues during COVID-19. Our panelists are involved in many of our coalitions, and we hope you will join us too. So thank you so much for joining us, and thank you to the captioner. All right, I'm gonna go back to slide number 1 because I want to take a quick picture with panelists. There you go. All right. Whenever Ruth is ready. Ruth, I'm going to send you the picture.
Okay, I took my own, yeah.
Let me see. All right, let me see. Make sure it works first of all. No.